Now, there was an appellate lawyer on the line, but he left for some reason. He said, look, this is a case, the judges go back and forth, and they put out these hypotheticals. Well, he didn't put out hypotheticals. Not across the board. They all went one way. Tax, tax, tax. Moreover, he had an opportunity to write an opinion in which he, as one of the circuit judges, one of the three on the panel, could have ruled that Obamacare was unconstitutional, just like the 4 justices did on the Supreme Court. The Supreme Court case, King versus Burwell, which they did a half a year later. But he didn't do that. Instead, he looked for a way out. And the way out was, look, this guy always wanted to be on the Supreme Court. He knew what he wanted. The lobbying effort on his behalf was unprecedented. So he points to the Anti-Injunction Act, which he said prevents us from hearing this case until 2015. That's what he said in the oral argument. So what he's saying there is, I got to wait for this tax/penalty to take hold, for it to be applied, and then it can be litigated all over again and come up to the court or some other court, and we can address it then. So he pushed it off. That's not what the dissent on the Supreme Court did or would have done. I felt quite confident that when it comes to the Obamacare case, Kavanaugh would have been persuaded by Roberts. George Bush also wrote a book, as my buddy Daniel Horowitz points out at Conservative Review. Kavanaugh working for George Bush when they were looking at a Supreme Court nomination, one of the vacancies that occurred during his presidency. And it had come down essentially to John Roberts and Michael Luttig. Luttig being a circuit court judge as well. Luttig is well known among conservatives and constitutionalist circles as the gold standard. An exceptional circuit court judge. As George W. Bush points out in his own book, Kavanaugh lobbied for Roberts. Kavanaugh lobbied for Roberts. Roberts won't forget that. And Kavanaugh won't forget it either. But that was poor judgment. Because Luttig, in my view, would have been an outstanding Supreme Court justice. So we lost Luttig, and we got Roberts. Now, I had backed Roberts at the time because he was considered fairly solid. But as it turns out, he was a risky pick. Then we get all kinds of arguments. Well, one of the gold standard nominees wouldn't have been confirmed. Well, Amy Coney Barrett was 46, too young. But then we hear it said that if there's another vacancy, the president will nominate her. So what? She's 47, 48? That makes a difference? Of course not. We've had presidents younger than her. And we've had justices younger than her. We've had justices with no judicial experience, that is, never been judges. That's okay. Elena Kagan is a perfect example. She was never a judge. While I disagree with her almost all the time, she's enormously bright. She knows her way around the Supreme Court. You don't have to have been a judge. Mike Lee was never a judge. Is there some question about his constitutional capabilities? I don't think there's any. So you hear these arguments. Well, there's, it's Susan Collins and Lisa Murkowski to deal with. So deal with it. Is Mitch McConnell not a leader of the United States Senate? The goal isn't to make it easy for Mitch McConnell. These are lifetime appointments, for crying out loud. The court is far more powerful than the framers of the Constitution ever intended and than the ratifiers would have intended. The ratification of the Constitution, if the ratifiers in the various conventions of the states had known that the Supreme Court would be as powerful as it is, they would never have ratified the Constitution. They were assured repeatedly, especially by Hamilton, it's the weakest branch, don't worry about it. And yet, it's the most powerful branch in many respects. Now, some of these questions were raised over the last week, and what happened was people who would dare to raise them were viciously attacked as spinning, as stabbing the judge in the back, as being dishonest. They weren't truthfully engaged by the inside the Beltway legal types. And that's the other thing. Kavanaugh doesn't get more Washington. There isn't another candidate who's more Washington than Kavanaugh. He was born there. He was raised there. Now, that in and of itself is not a disqualification. I fully recognize that. But you have to put the pieces together. One of the people pushing Kavanaugh the hardest, according to published reports, was the counsel to the president, Don McGahn, who I happen to think is a terrific guy. But he has spent his professional career in Washington, on the FEC and as a lawyer, which is great. But he clearly put his finger on the balance. And there are others who I know quite well who called me, who pretend to be honest operators, who weren't, quite frankly. Who weren't. Now, while NBC got it wrong and said some deal was cut with Kennedy, apparently, to get Kavanaugh or one of his clerks, they only got it partly wrong. Apparently, Kennedy did, in fact, mention Kavanaugh or one or more of his clerks as possible replacements when he decided to step down. That doesn't mean there's this ironclad deal. But I'm now convinced that despite all the input our president received, and he received a lot, he sought a lot to his great credit, that in the end he really was going to go with Kavanaugh no matter what. And there's another issue. Aside from immigration and abortion with illegal aliens and religious liberty, there's some questions about all that. Beside all that, his view of impeachment is absurd. If the president acts or does something dastardly, that could be an impeachable offense. No, it can't. There seems to be some confusion. We've talked about impeachment, about what impeachment is all about. Impeachment is not whatever the House of Representatives says. Not if you follow the Constitution and the rule of law. Can they muscle their way through and do it? Sure, if they have the votes, but that's not what's intended. You can look at Madison's notes and see the debate that took place over impeachment in the phrases high crimes and misdemeanors and bribery and so forth. Alan Dershowitz is running around, wrongly citing himself in his book, saying it has to be an actual crime. And yet, the framers in their debate specifically said, no, it doesn't. On the other hand, they rejected the word maladministration that was used by the Parliament when it came to impeachment. They said, no, Madison says, that's way too vague. Maladministration can mean anything. Again, we've talked about this, and we'll have to do it again in the future at some point. But high crimes and misdemeanors, sure, if a president commits a crime or is perceived to have committed a crime, because in my with the Justice Department memos, whether I personally agree with it or not is beside the point. He can't be indicted. So if he's perceived to have committed a crime or believed to have committed a crime by the House, of course they can seek to remove him by voting on articles of impeachment and sending it to the Senate for trial. But there's some things the president may do which aren't per se criminal. Might even be worse. A major abuse of power. Violating separations of power. Like Mr. Obama, among others. So, impeachment does have at least general definitions, traditions, understandings. Doesn't require an actual crime, as Dershowitz says. That it requires much more than what Kavanaugh says. And if he's going to be on the Supreme Court and he holds to that position, I don't think that helps the president one iota. Now to the positive. Kavanaugh is very good on addressing matters related to the administrative state. If you read the Liberty Amendments, one of the amendments, the reform amendments I propose, is to muscle up and reinforce the Commerce Clause. Why? And not just the Commerce Clause. Congress's role in the regulatory state. Because of this Chevron decision, in which the Supreme Court decided, and I'm doing a very summary sketch of this, but I write about it extensively in the Liberty Amendments, that deference, really almost absolute deference, is to be given to the administrative state. So the administrative state can determine if the administrative state is out of control or not. And I strongly reject that, which is one of the reasons that I have one of my reform amendments in the Liberty Amendments, which compels Congress to get involved in the regulatory state in a much more meaningful and substantive way than it even does today. In fact, one of the reform amendments that I put in the Liberty Amendments states, and I do this by paraphrasing, that no regulation that has an economic impact of $100 million or more, or may raise constitutional issues, can be issued unilaterally by the bureaucracy until it is reviewed by a special joint committee of the House and the Senate, which has 6 months to review it. And after 6 months, if it hasn't reviewed it, the regulation dies. Now, Mr. Kavanaugh appears to be pretty good on this issue of the administrative state. Pretty good. So that's one in his favor. And I don't deny that. But most of the cases that come before these courts, including the Supreme Court, are not cases of any meaning to you, or they don't have broad-based constitutional impacts. They're related specifically to the parties in front of the court. But there are times when that's not the case, when the implication is much broader and more societal than just that of the parties. I'm not saying that Mr. Kavanaugh is Ruth Bader Ginsburg. I'm not saying that he's Sotomayor. I'm saying I don't know what he is. He's not them, but it's a risk. And let's say 3, 4, 5 years from now, he turns out to be Antonin Scalia II. It's a wonderful thing. I'm not here to sabotage the man, remember? My entire purpose here is to raise questions as a constitutionalist. I wrote the book Men in Black in 2005, long before that and long after. We've talked about the Supreme Court, the rule of law, and of course, every day the Constitution, virtually. Every day. I do not believe Susan Collins and Lisa Murkowski, two of the most liberal members of the Republican Party in the Senate, should have a trump card on our nominees. I don't believe their radical positions, and they are radical on abortion, including abortion on demand and partial birth abortion, should be able to determine in the end who is or is not nominated. Sometimes, ladies and gentlemen, you take a stand. And you fight to the end. And you know what? Many times you win. If we had nominated a gold standard candidate, the president had, I should say, and we lost, we're still here to fight tomorrow. That slot hasn't been filled by a leftist. And it also would have been possible to pick up more Senate seats, because the court, again, will be center stage. And I think our base would turn out even more so. That's not the reason to nominate a gold standard candidate. But it is a consequence of what the Democrats do to our candidates. You should look at this differently than your typical political or policy issue, where you are desperately trying to endorse whatever the president does. You shouldn't look at it also as an opportunity to sabotage the president like the Never-Trumpers, who happen to be very excited about this nominee, by the way. You should just relax, use your brain power, take in what I'm saying, take in what other people say, read it, and draw your own conclusions. This is not a House seat for 2 years or a Senate seat for 6 years. Mr. Kavanaugh will outlive me, and he will outlive many of you. And so this is serious business. I'll be right back.
Mark Levin.